Welcome to Safe on 7, Forsyth County Domestic Violence Center. Among the agencies you will find located here are the Forsyth County District Attorney's Office, the Forsyth County Sheriff's Office, the Forsyth County Clerk of Court, Family Services Incorporated, and Legal Aid of North Carolina. Clients of the center are able to obtain information, protective orders, advocacy and referrals, as well as information concerning their court cases. We are so glad that you're here. You have taken a very important step in the process of making things safer for you and your family. We understand that this is not an easy step to take, and we want to do all we can to make this process easier to understand. It is against the law for your partner to abuse you. Abuse is slapping, hitting, grabbing, pushing, strangling, kicking, wrestling, hair pulling, punching, or any other act that causes injury. Stalking or harassment are also considered abuse. Abuse can also be threatening to do any of these things to you and putting you in danger of serious injury. For example, threatening to attack you with a weapon or forcing you to have sex when you didn't want to or in ways you didn't want would constitute abuse. This video is not a substitute for the legal advice and representation that would be provided if you hired an attorney to represent you. The act of representing yourself in court is called pro se representation. While you always have the right to represent yourself in court, the court process can sometimes be very difficult to understand. Even though you are not an attorney, the court will expect you to know the laws and behave professionally in court. Any time before the 10-day hearing, you may try to obtain an attorney. If you want to find an attorney in your area to assist you, you may call Legal Aid Centralized Intake at 1-866-219-5262, or you may call the Lawyer Referral Service at 1-800-662-7660, or on the web at www.ncbar.org/public-pro-bono/lawyer-referral-service.aspx. This service is available 24 hours a day. You may have been referred here to ask for a 50B domestic violence protective order to protect you and your family from abuse. 50Bs are issued between people who have been married or divorced, current or former household members, family members such as a parent, child, or grandparent and grandchild, persons of the opposite sex who are in or have been in a dating relationship, or persons that have a child in common. Alternatively, you may be here for a 50C, which is a no-contact order for sexual assault or stalking victims when there is no previous relationship between the individuals. There are 3 basic steps to obtaining a 1-year protective order. First, filling out the 50B or 50C forms. The second step will be a short, informal hearing with the judge shortly after filling out the forms, called an ex parte or temporary hearing. This is the hearing for the judge to decide if he or she feels that an ex parte order needs to be put in place immediately without hearing from the defendant. This may also be called a temporary or 10-day order. Any 50B or 50C ex parte order must be served on the abuser to be in effect. The third step will be a civil court date that will be scheduled in up to 10 days after the ex parte hearing. This is the hearing where the judge will ask for evidence from both parties and make a decision whether to issue a 1-year protective order against the defendant. It is important to keep in mind that even though the judge may not grant the ex parte or temporary order, he or she may still rule to issue the 1-year protective order at the 10-day hearing. You will be given another opportunity to tell the judge what happened and why you feel you need protection. Some things to keep in mind about the legal proceedings. There are 2 legal avenues in the court system. One is civil proceedings, and the other is criminal. A 50B is considered a civil process and is issued in civil court. Criminal charges like assault, trespassing, or communicating threats may have been issued against the person from whom you are asking for protection. This means you may have 2 separate court cases, civil and criminal, pending relating to the same situation. You may even have court on 2 or more different days. If you receive a subpoena to come to court, always check the case number on the top of the form or ask the deputy who brings you the subpoena. Civil cases will contain letters CVD in the number. These relate to your 50B form. Criminal cases will contain the letters CR. You do not need to hire an attorney if you are the victim in a criminal case. The district attorney's office will handle representation on behalf of the victim. If you file for a civil protective order, you are acting as your own lawyer. Safe on 7 staff are not attorneys and may not give any legal advice. If you wish to request to be screened by Legal Aid of North Carolina to determine if they could possibly represent you, then you must complete the purple application form. If you have civil court dates beyond the 1-year protective order hearing involving divorce, child support, and/or custody, you should strongly consider seeing a lawyer if you think the other person will hire a lawyer, or if you think the other person will try to get custody of your children. The first step in obtaining a 50B or 50C protective order is to fill out a 50B or 50C form. This will ask the judge to protect you and your family from abuse. By filling out a 50B or 50C complaint, you are asking a judge to have a person stop abusing you or harassing you. Additionally, you may request protection for your children or any other family or household members. You may also ask that the abuser not be able to contact you via telephone or in person at your home or work. You may ask for possession of your home, for the police or sheriff to remove him or her and to help you return safely, give you possession and use of the car, and to order him or her to stay away from you and/or your child's school and daycare. If you think such additional measures are necessary, you should request them in your complaint. However, there is no guarantee that a judge will order all of these conditions. While a protective order is not a way to gain custody of your children without the presence of abuse, if one of your children witnessed or was present during incidents of abuse, or you feel they may be in danger of harm from the abuser, then it is critical that you request temporary custody of your children in your complaint. However, be aware that temporary custody is not a substitute for making a permanent custody or child support arrangement. If you do not request temporary custody of your children, it may be a good idea to think of a neutral party who can be a go-between for you and the person while the protective order is in place, such as trusted relative or a friend. This must be approved and added to the protective order by a judge. At this time, we will cover how to fill out the 50B form. First, we cannot overemphasize the importance of telling the truth throughout this entire process, because being misleading, embellishing the truth, or describing an act or event that did not actually occur will likely cause the order to be denied. Please read all sections and complete any sections that apply to your situation. If they do not apply, just leave the section blank. The person filing for a protective order will be the plaintiff, and the person they are filing against will be the defendant. 50Bs are issued between people that have been married or divorced, current or former household members, family members such as parent-child or grandparent and grandchild, persons of the opposite sex who are in or have been in a dating relationship, or persons that have a child in common. On the 50B form, you must check the appropriate relationship box. Same-sex couples should visit www.projectrainbownet.org/laws.html for further information on how to apply for a protective order. Section 4 is where you will describe what has happened that makes you afraid. Remember that you're writing your complaint for a judge and will have to go before that judge if you are requesting an ex parte order to answer any questions they have about what you have written. Therefore, it is very important to show the judge on paper why you are afraid now. It is important for you to be as detailed as possible about the abuse and when it occurred. Use specific dates and describe the acts of violence and the injuries that occurred from it. For example, if I was seeking a protective order against my brother, and last month my brother threatened to kill me with a butcher's knife, I would write that my brother threatened to kill me with a butcher's knife last month on June 20th, 2010. When you describe the domestic violence against you on the complaint form, start with the most recent act of violence first. Then go back in time and describe each act of violence. If the abuse has happened over a long period of time, list the 2 most recent incidents and the 2 worst incidents and add, "The defendant has abused me several times over the past blank years." Don't hesitate to make a simple list using bullet points to indicate the act of violence and the date that it occurred, starting with the most recent act. So my list might look something like this. Describe each incident of domestic violence. Domestic violence can include hitting, slapping, pushing, shoving, grabbing, choking, and use of weapons such as guns, knives, bottles, etc. It can also include threats to do any of these activities and threats to kill you. Threats can also be nonverbal, such as, "I'm afraid of my brother when he drinks because my brother always hits me when I tell him to stop drinking alcohol." It can also include stalking and harassment. If your abusive partner is violent while using alcohol and illegal drugs, or in the possession of firearms, tell the judge in the complaint and remind him or her of it in court. Section 5 is about any harm or fear of harm to any children. Section 6, check here if you believe you are in immediate danger. Sections 7 and 8 is for if you are asking for temporary child custody. Section 9 is for identifying any firearms the defendant may have. Section 10, describe any past use or threats involving deadly weapons by the defendant. Section 11, describe any history of the defendant threatening suicide. The next section is for you to identify what you would like the judge to put into the order. Please remember that this is a request, and the judge may or may not grant any or all of your requests. Again, check all that apply and leave the others blank. Completing the 50C paperwork is very much the same. After the forms are completed, you will be sworn in by the clerk of court and then taken before the judge for a hearing.